You're watching Left, Right and Centre now for a very important story. So an arbitration that India lost, this is the Cairn arbitration case. Now this has also resulted in a retrospective tax fix. And to understand a story like this, because for many this will be an extremely complicated story, but it's very, very important. So let's explain how the Cairn case unfolded. So Cairn India is a company which listed on the Bombay Stock Exchange in 2007. Let's go full frame so that you can see those graphics. January 2007. Then in December 2011, Vedanta completed the acquisition of 58.5% in Cairn India from Cairn PLC for $8.7 billion. In January 2012, the Supreme Court ruled in favor of Vodafone in the 2 billion tax case, that famous case if you recall. In March 2012, the government introduced what is now known as the infamous retrospective tax amendment in the finance bill. Why did the government do that? And we are talking about the UPA government, mind you. This is March 2012. In January 2014, the IT launches a retrospective tax probe into transactions undertaken prior to an IPO. Then in March 2015, Cairn PLC commenced international arbitration proceedings against the Indian government because they felt that this is not correct. In December 2018, the hearing was concluded in that case. Now let's tell you what exactly is the ruling in this case. The ruling in the International Court, an international arbitration tribunal, has ruled that India's tax claim was not valid. The case was ruled by a 3-member tribunal. The tribunal also comprised of a judge appointed by the Indian government. The ruling says, and I quote, and this is significant, that India's claim of 10,247 crore rupees in past taxes is not a valid demand. Now let's quickly move to what the Cairn, this company, has said. What have they said in their statement? Cairn on the tax blow to India. They say that the tribunal ruled unanimously that India breached its obligations on Cairn. Now, that's a very, very significant point that Cairn makes, hoping that they will get their money back. They say the tribunal has awarded Cairn damages of $1.2 billion plus interest and costs, and damages will now become payable. Let's now get you the Indian government, what the Indian government is saying on Cairn's arbitral victory. What does the government of India say? They say, as of this moment, tight-lipped because studying, they say, we'll study the award in arbitration case in all its aspects carefully in consultation with its counsels, which of course is the right thing to do as of this moment, having lost this case. They also say, and I quote, after such consultations, the government will consider all options and take a decision on further course of action, including legal remedies before appropriate fora. Now, why does this case come about? Why does the Indian government feel that it has legal options to explore? Let's quickly tell you what is retrospective taxation for you to understand where is this problem coming from. So I'll ask the producers to pull up the graphics on what is retrospective taxation. So retrospective tax allows a country to pass a rule on taxing certain products, items or services. It charges companies from a time behind the date of which the law is passed, which means that if, say, such a law is passed today, then this law itself will allow the country to tax a company not from today, but retrospectively. Now, this many countries feel, or many companies operating in different countries feel that this is not fair. Countries use this route to correct any anomalies in their taxation policies. Now, India is not the first country, by the way. Apart from India, the US, UK, Netherlands, Canada, Belgium, Australia, Italy have retrospectively taxed companies. So we are not the only ones. And last, what are India's legal options, you ask? Let's put those graphics on screen. What are India's legal options? The legal option is to appeal or not in a court of Netherlands. That is legal option number 1. The government is appealing against the Vodafone award, by the way. And the centre may also appeal in this case, in the case of Cairn. What exactly is this fix and how do lawyers look at this? and what is in their wisdom, the correct way forward. I want to introduce Anuradha Dutt. She is the counsel for Vodafone, and we also have Arvind Datar, counsel for Cairn Energy. Thank you very much, the two of you. Mr. Datar, let's begin with you. We've given an explainer because you do realize that for the common viewer, and me too, this is a very complicated story, right? So it's important to understand what retrospective taxation is. Why is it becoming a problem, particularly in the cases of these companies?
Retrospective taxation in any country is a problem. For example, in the Cairn case, the transactions took place in 2006. At that time, what was done was perfectly legitimate. There was no tax on the transactions in 2006. Now, 2012, the Vodafone judgment came, and that was a case where they said that if shares are transferred by non-residents outside India, there'll be no liability to tax. Now, that was changed retrospectively, and they said that even if shares of foreign companies are transferred, India will get the right to tax under certain circumstances. So this was the law made retrospective from 1/4/1962. And they applied this retrospective law for Cairn as well, because even in the case of Cairn, transfer of shares took place in the UK, and they tried to tax those transfers in 2014, which had taken place in 2006. Now, when that took place, then Cairn, which is from the United Kingdom, and we have got a bilateral investment treaty between India and the United Kingdom. So under Article 3 of that treaty, there is an obligation of both countries, not only India, but even the United Kingdom, that any investments made by an Indian in the UK or by a UK company in India will be treated fairly and equitably. And if you don't treat it fairly and equitably, it will be a violation of the treaty. And that's what the tribunal held, that amending the law retrospectively is completely wrong. I mean, just take a simple example. Today, suppose an Indian, a subsidiary of a UK subsidiary of an Indian company enters into transactions which are perfectly valid, there is no tax liability. And just imagine if in 2028 or in 2030, UK changes the law retrospectively and says, sorry, what you did in 2020 is now taxable. So pay the tax with interest and penalty for a period of 10 years. So that's where the problem arises.
Okay. Okay. We have Mr. Mukesh Bhutani, also senior partner, BMR and Associates, along with Anuradha Dutt. Mr. Bhutani, what is the rationale that has been presented by governments? I'm not just talking about the Indian government when this law was introduced, but governments the world over. We're not the only country.
Well, I don't know whether there is any rationale by way of an official statement available by the government of India. One can merely speculate that the government would be, on one hand, concerned with its sovereign power, which is the power to legislate a tax law retrospectively, right or wrong, fair or unfair, moral or otherwise, versus the obligation that it has under public international law towards a convention in general. And here it is the Bilateral Investment Treaty Convention. So, at least based on reading the operative part of both the arbitral awards, it seems that besides holding that there was unfair treatment accorded to the respective investors, Netherlands in case of Vodafone and UK insofar as Cairn is concerned, at least in the Vodafone order, it appeared that the government directed that the retrospectivity part of the law was something that was unfair as well, insofar as the investor rights are concerned. Now, we all know that the law went through a tremendous amount of debate and it attracted a lot of criticism for India. But the fact is that under the constitutional framework, there is a right for the parliament to legislate a law.
True, absolutely.
Application, and that power goes beyond the power of the judicial.
You know, I just want to broad base this a little, Ms. Dutt, before I come to you. See, the Vodafone case of which you were a counsel, and now the Cairn matter. Do you think international investors are going to very keenly watch what India's response is going to be?
So I think international investors were quite stunned in 2012. As I have said before, that when an investor decides which country they want to invest in, they see whether there is a legal certainty, tax certainty, and a rule of law.
Yeah.
And unfortunately, India has violated all these in the Vodafone case, and as a result of the retrospective amendment, there are other so-called victims like Cairn Energy. So, I would also like to say that, you said that all over the world, every country has the power for retrospective amendment, which is absolutely right. But there is not a single instance where a new law was imposed retrospectively. Even India has brought about retrospective amendments for last how many decades, but it was always either two high courts were giving different views, so an amendment was brought to clarify, or if a Supreme Court gave a view where they have collected taxes and they don't want to give back the taxes, so they bring a clarificatory amendment. It's the first time that you introduce, at least in India, first time they introduced a retrospective amendment to bring out a new tax, because the Supreme Court clearly said in Vodafone case that this is a policy decision. You've not got amendments to the Income Tax Act to bring about such transactions through tax. Please bring them in future. Sure. But what the country does is, our country does is brings it retrospectively for closed transactions. That's very important.
Okay, and that does not do well or augur well with investor confidence. Mr. Datar, my final question to you.
No, and in fact, just 1 second. In England and in Australia, they brought retrospective amendments, but then they grandfathered the cases which courts had decided in favor of NSFC.
Sure. Mr. Datar, my final question to you. First of all, I know you would hope that the government clears the dues, but the point is, the government too says that it has its legal options. Realistically speaking, do you see any closure on the issue of retrospective tax, unless of course the law itself is repealed, which obviously the government is no mood of doing? Is this a long legal battle even now?
No. Now there is an appeal in the courts of Netherlands because the arbitration seat was Netherlands. I don't know how long the Dutch courts will take to decide the appeal, but there is one round of appeal and that's it, and then that will decide the fate of the case ultimately. So I don't see a much more delay, maybe a couple of years more. I don't know how much is the pendency in the Dutch courts as far as appeals are concerned. Yeah. And only on talking on sovereignty, which Mr. Bhutani just mentioned.
Yeah.
Every country has a sovereign right to tax. Nobody disputes that. But when you enter into a treaty, you surrender partly your sovereignty. India and UK both promise that though they have the sovereign power to tax, they will ensure that the taxes are fair and equitable. And if they are not, then either company can bring proceedings against the other company. And here the main problem of retrospective taxation. There's an old case between Russian investors and Mongolia. The taxes were increased hugely. And the tribunal said as long as they're prospective, it's okay. But if it's retrospective, then there is a serious problem. Because you bring in complete legal uncertainty.
Sure.
You see, the past becomes uncertain.
Sure. All right. Thank you very much, Mr. Datar, Ms. Dutt, as well as Mr. Bhutani for joining us on this discussion.